Have you ever wondered before where somebody has been convicted as a criminal and tomorrow you see him in the public space, occupying public office, being voted for into public office, being entrusted with so many things that have to do with public trust? And you wonder, is this man not an ex-convict? Was he not the one that was convicted of a criminal offense? It bothers you. What is happening? What is wrong with our criminal justice? There is what is called prerogative of mercy. There's what is called a pardon. Today we'll be looking at prerogative of mercy. We'll understand what is prerogative of mercy, what is the effect of prerogative of mercy on a convicted criminal. Follow me as we discuss this topic today. Prerogative of mercy. Click on the subscribe button, like this video, and share with your friends so that we'll get more enlightened. Follow me. Hi, my name is A.I. Ango. I'm a legal practitioner, a notary public, and a chartered arbitrator. Today we'll be discussing prerogative of mercy. What is prerogative of mercy? Who can grant prerogative of mercy? And what is the effect of prerogative of mercy on an ex-convict? Prerogative of mercy is the power given to a president or state governor to grant pardon to an ex-convict. Meaning, the president or the state governor is empowered by the Constitution to baptize, to cleanse, to wash an ex-convict free from all the encumbrance, all the restrictions that an ex-convict suffers. Where somebody commits an offense, commits a crime, and he has been arrested, prosecuted, convicted, and sentenced to prison, and he has served his prison term, and president or the state governor now decides to grant him prerogative of mercy or pardon, then that person is completely washed of all the restriction an ex-convict will suffer. It is natural, it is normal, it is understandable, it is our laws that when somebody is an ex-convict, there are restrictions, there are things he cannot enjoy like the other normal free citizens. For example, an ex-convict cannot hold public office. An ex-convict cannot be voted for. An ex-convict cannot be appointed into public offices. These are restrictions an ex-convict suffers. But once a pardon is granted, an ex-convict can enjoy all these things. So, a state governor or a president is empowered by the Constitution to grant an ex-convict pardon. This is different. Prerogative of mercy is different from an appeal. It is different from an appeal. For you to enjoy prerogative of mercy, the person must have served his prison term before he can now be granted a pardon. Prerogative of mercy can come in 4 different forms, as constitutionally stated. One is the pardon, which is a complete washing away, we say complete baptizing of the convict or ex-convict rather, and now he is made whole. His sins are forgiven. The restrictions are taken away from him. He is now free like any other citizen of that country. That is a pardon, and that pardon can be granted either by the president or the state governor. Where it comes to federal crimes, federal offenses, the president can grant, is the one only that can grant that one. Where there are offenses against the army, navy, or air force, it is only the president that can grant that pardon. Where there are convictions by a court martial, it is only the president that can grant that kind of pardon. The state governor also can grant pardon, but with restrictions to any offense against the Army, Navy, or Air Force. But other than that, he also can grant the pardon. Also, there's another form of prerogative of mercy, which is the respite. Now, respite is like a succor given to the convict, suspending the punishment for a period of time of indefinitely. A person may be sentenced to prison, and the governor or president can step in to say, okay, hold on, don't send him to prison for a certain period of time, or hold on, don't send him to prison until I decide. So that is respite. There's also substitution. It's another form of prerogative of mercy, where the president or the state governor is empowered to substitute the punishment for a lesser one. It is still another form of prerogative of mercy, where somebody has been convicted and sentenced to a prison term. The president can decide to say, okay, I'm stepping in, or the governor say, I'm stepping in to reduce the prison term or to substitute it for another prison term. Some other persons may be non-custodial sentence, meaning you are convicted and sentenced to prison, but you will not serve in the prison correctional center. That is non-custodial. The president or state governor can come in with that prerogative of mercy. Then there is the remit. The remit is where a portion of the sentence or the punishment is taken away while the person serves a part of the punishment. The state governor or the president can decide on that as well. Now, where the last three forms of prerogative of mercy are given to a person, either the remit or the respite or the substitution, where this is the form of prerogative of mercy doled out to an ex-convict, that will not take away all the restrictions of an ex-convict, because it does not give you that holistic cover of freedom. It only reduces or mitigates or suspends the punishment, but the toga of an ex-convict is still attached to the person. It is only the pardon that completely cleans the person from all this restriction. Who can grant presidential? Who can grant a prerogative of mercy? We earlier said it is either the state governor or the president of the country. These are constitutional powers. These are powers that are embedded in the Constitution of the Federal Republic of Nigeria. Prerogative of mercy, section 175, grants the president that power. It's the state government the power to grant prerogative of mercy. Now, how do a convict or an ex-convict get to be granted that prerogative of mercy? The president or the state governor has a committee that advises him on prerogative of mercy, who to be accorded that and who not to be. When an ex-convict decides to apply, he must put an application to the prerogative of mercy committee, who will now x-ray the application to see if there are cogent reasons, if there are essential, exceptional circumstances that will grant them, that will inform their decision to advise the state governor or the president to grant that prerogative of mercy to the applicant. It is their advice now that the president or the governor will look at it and then grant that prerogative of mercy. The governor or the president is the only person that can approve that. Whenever an application is being put up to, it is sent to the Council of States. And the president or the state governor is the chairman of the Council of State. And so the power to grant or not to grant lies with the chief executive, who happens to either be the governor or the president of the state. And when such application is being considered, then a person can be granted prerogative of mercy. For example, there are some governors, ex-governors in Nigeria, who have been convicted of financial crimes, and they have been sentenced and they have served their prison terms. But the president granted them pardon, cleansing them of all allegations, of all restrictions of an ex-convict, meaning they can now occupy public office, meaning they can now be voted for as clean citizens. There are a lot of arguments against this prerogative of mercy. Some say this will encourage people to put their hands into public funds. This will encourage people to still commit financial crime, because they will say after conviction we may apply and the president may grant us prerogative of mercy, and then everything comes back to normal. Some are saying this is politically motivated and it is not good for the growth of the country. These are valid arguments. Some are even postulating that this should be a discouragement to the financial crime fighters, because they will put a lot of effort in investigation, a lot of effort in prosecuting, and then at the end of the day, the person is sentenced, and then after that he's granted prerogative of mercy, and then he comes back clean. All the effort put in is a waste. The money spent is a waste. The intellect is a waste. The time is a waste. The taxpayers' money is wasted. That is argument against the prerogative of mercy. While to some others, they are saying this is a good ground where probably somebody is convicted wrongly. He can be granted prerogative of mercy, he can be granted pardon, and he can come back to give back to the society what he has. That could be a valid argument, and that will not serve a restriction, because somebody may have something that will develop the country, but because of the restriction of an ex-convict, he may not have the opportunity to contribute. But if he is granted, he can come and contribute to the growth of the nation. That is giving a second chance to somebody. This is argument for the prerogative of mercy. However, we must understand that tomorrow, if you see somebody that has been convicted of crimes and you see him occupying an office, then you must understand that either he has been granted prerogative of mercy by the state governor or the president. But if he has not been, or she has not been granted that, you have the right to challenge that person, and that person will surely be taken off that office. Don't get mad, just get a lawyer. Thank you for watching this video. We'll encourage you, we'll love you to subscribe to this video and also share with your colleagues, so that whenever we put up new videos, you will be alerted on them. Thank you. See you next time.